Buscrime5 class. So you have already seen all, I think, the groups and the topics that you are supposed to work on. You might have seen that on Thursday I uploaded the first version of it, and on Friday I think then an updated one. So because there was one error where one group just disappeared, and other members have also not been put into the groups that they told me. So therefore, yeah, now I think everything should be in order, and yeah, you have received, I think, quite a generous deadline to work on that, and overall it accounts, as you see there, for 20 points, and the instructions, I hope, are clear. For the cases, you may see that for some of you the cases may be longer ago, but maybe rather prominent, so therefore I think enough information should be available, because also scholarly research has then covered that already. More recent cases may then maybe more rely on current reporting. Maybe there is not yet much scholarly work that has been done on these more recent cases, but then obviously you can use what you find in general news reporting and maybe other documents that are made available online. Yeah, so all of these 20 cases are obviously dealing with rather big corporate scandals, where obviously sometimes individuals have been particularly prominently involved, sometimes the whole company, and the questions that you should answer, you find that you know the instructions. So if there's any question, I think most of you may not yet have started doing research about this, or have you already? That would have been surprising. So therefore, that's clear. So as soon as you encounter any problems in your research, please let me know, and I will be happy to give you some advice. Are there any questions regarding these groups and the topics at this point that we would like to raise already? Yeah.
That case is prosecuted by many countries, and you get all the countries too.
What is your case? What's your group's case? Oh, the Volkswagen case, yeah. Well, I think for every case I added countries. Yeah. The countries you find there in the brackets are the countries that you should have a look at regarding the prosecution. So for the Volkswagen case, what did I put there? Okay, only the US, no? Okay, and then it should be limited to the United States. Yeah, the Volkswagen case is one example, like many others, that has been prosecuted in many countries, but obviously you cannot cover all prosecutions. Yeah? Yes? Well, that's up to you, but make sure that the overall word limit is not increased, yeah? So the maximum shall be 2,500 to 3,000 words, I think. So if you see that there are a lot of problems and legal issues that you would like to address, then you may need to keep the summary comparably short. Yeah, so the summary of the facts, don't underestimate that. That is a skill that you should also develop, for example, for your future work, to be able to summarize the important facts in a concise way. Only what matters for the case. So don't tell a story about, well, on a sunny day that person went out and then went about to do whatever. So I see that for some cases, so which is your case, the FIFA case, yeah. I see for some cases that the facts may be quite elaborate, yeah? Maybe quite a lot. And for that, one skill is to boil it down to the important things. No? It may sometimes not be that easy. If you have a case, for example, you also mentioned that where there seem to be many, you can say, sub-cases, then you may mention these in the summary of the facts, but then the analysis may focus on one or two which you consider as particularly important. So obviously, as this assignment accounts only for 20 points, I didn't want to require you to write 5,000 or 6,000 words, because that would be disproportionate to the weight that it has with regard to the overall grade. So therefore, it is a limited space. You may need to focus, but then also say why you focus on that. So what makes that, what you point out, particularly interesting. You may, in many cases, not be able to cover the whole thing in the all detail in just 3,000 words. That's most likely not possible. If we then also think about the summary of the fact, that takes a bit of that out already. No. Okay. Any other question regarding that group work? Yeah.
Okay, for example, for the Volkswagen example, so you have to cover the entire Volkswagen group.
Yeah. Yeah. But again, you may not be able to cover all of these sub-cases then maybe from different subsidiaries within the overall group in all detail. Yeah? Try to look at it from the perspective of what are the interesting, also legally interesting aspects, or sometimes also practically interesting aspects regarding the, I mean, as I formulated, I think in the guiding questions, yeah, maybe some practical obstacles regarding the enforcement, regarding the investigation. Maybe you come across some interesting facts which are worth to be mentioned, because not only the law, but sometimes also very practical issues may make the enforcement difficult. Or you may also obviously point to legal interpretation facts. Yeah? So for example, you may say, well, here it is highly doubtful whether anything that the company actually did was illegal. I mean, we should not consider that everything that a prosecutor does or considers is always right. Sometimes interpretations may be quite doubtful, and then you may also find arguments why maybe that company or that particular person did not violate the law according to the law at the time. So these will all be some aspects. Okay, yeah, so I look forward to that, but obviously that is now, there is still a bit of time that you have to do that. Now, for today's class, you may have seen no new slides. The reason is that we complete what we started last week, and then in the second half today, you will be asked to solve a case. Isn't that exciting? A little case, not too little, but I think then for the last half, it will be, we will be able to do that. That means you will solve the case on your own or discuss it with your friends, and then we talk about the case, how to solve that case, which is dealing with corporate and directors' criminal liability. Right, so a bit of a practical case-solving element as well, because obviously we will also want to apply the knowledge that we have gained here. However, for the case that we will look at today, it actually differs from what we have learned so far about criminal liability of corporations or companies or juristic persons in Thai law. So therefore, when you read the facts and when you read the law, particularly the law that applies here, you will see, oh, this is still another way of criminalizing the actions of juristic persons. So we will look at that later. Before we go there, let's just think or reconsider what we talked about last time. So we were about to finish the chapter about corporate criminal liability, and we were about to move to talk about the director's liability. So what can you tell me about corporate criminal liability in Thai law? What is it that we have so far covered in that regard? Yeah.
Okay, for what we have studied, there are three forms of corporate criminal liability. First form is basically the law specifically mentions corporate criminal liability. And in the same case, it could be an act for a law, they criminalizing certain acts or omission, or persons with specific characteristics, which often include juristic persons. And the first
criminalization methods. One was, as you said correctly, where the law explicitly says that companies or other juristic persons shall be covered. Specific offenses, we went through some examples. Then the other form was where a certain characteristic is contained in the law that refers, for example, to the holder of a permission or other examples, an oil or fuel trader or other examples here. And if these characteristics are met by a juristic person, then they would also be covered under this law. And then we also learned that the provisions that do not make any specific reference to either companies or juristic persons or to any characteristics, but just use the general term whoever, that this whoever may also, according to the interpretation of the Supreme Court, also cover juristic persons. Now, this last category is a bit disputed, at least among scholars. Even though, these decisions now go back decades, so you may say it's well-established law in Thailand, but it is still, scholars may still be not fully comfortable with it. Why is that so? Why is there a bit of a controversy about the question whether this whoever shall also cover juristic persons? Why is that controversial? You can say, well, whoever, all persons. Juristic persons are also persons, so what's the problem? Yeah, but what is maybe the problem? You don't see any problem. Any problem? Yeah, but isn't that great? If it's broad, it can cover everyone. Why is that a problem? Yeah. Right. So it is in the general criminal code, but again, isn't that very practical if you can apply all crimes also to juristic persons? It's a catch-all solution. Very effective enforcement. Yeah, okay. Why could you maybe make that argument that the drafters may have not intended that? What is maybe an indicator for that? Right, yeah. So we look at the drafting history also, and we've seen that the criminal liability of juristic persons has initially, in the very first act that we looked at, not been included in the criminal code. It was put into a separate act. Then, however, it was merged at some point into the criminal code. However, that was the previous criminal code, not the actual one that we are still looking at nowadays. Because the criminal code that we looked at, or that we look at nowadays, that we have, or that is still in force nowadays, the criminal code of 1956, that did not have any express corporate criminal liability, and instead, again, a bit you could say, copying what has been the state of affairs before, these offenses were put into a separate act, which is an important indicator of what the intention of the drafters may have been not to include juristic persons under the term whoever. What could be another indicator that we also mentioned besides now this drafting history, but if you look at the provisions that may also point us maybe to the direction that maybe juristic persons were not intended to be covered? Can you think of another indicator? If you look at the provisions, what in these provisions is a bit awkward if you think that also juristic persons shall be covered?
Because these provisions also include
Okay, very good. That could be an argument. The provisions that are then applied to juristic persons include as one kind of punishment also imprisonment. Okay, but that obviously cannot apply to juristic persons. So you may say that is also a bit of an oddity here. And speaking of punishments, well, murder, I think, may be one of the crimes that can be committed by a juristic person. We looked at the liquid gas explosion case. That was negligent manslaughter, but you can make it an intentional case too. So I think companies may be able to kill. Yeah. Okay, yeah, so the amount of the fines may also be an indicator that, for example, in the case which we looked at, yeah, the liquid gas explosion case, out of which then the case, the decision 3446 out of 2437 developed, there obviously the law that was applied there was section 291 dealing with negligent manslaughter or negligent killing, and there you see the maximum fine at that time for killing a person, or several persons obviously, was 20,000 baht only. For a natural person that may already be at that time a reasonable punishment, which you may however also doubt, but for a company you may indeed ask, isn't that too cheap? And you will see later today in the case study that you will do, you will see the modern way of drafting is to account for the fine by calculating it based on the revenue of the company. And that is then very flexible. So high revenue means high fine. Yeah, so also that could be an indicator that maybe these provisions were not initially intended to cover juristic persons. Nonetheless, they have been extended in that way. Now, what are the two ways of reasoning? So we looked at two Supreme Court decisions, which are the most influential ones because they were the first that established one way of liability, which was for intentional crimes, and then the other for negligent crimes. So what can we tell about the way of reasoning? How did the Supreme Court find now a solution, or what kind of doctrine did it apply in order to find them criminally liable? First of all, the reasoning in the trademark forgery case, so the first decision about intentional wrongdoing. What was the way how the Supreme Court approached that?
So the Supreme Court used the civil code, but they used one of the provisions to explain that the intention of a juristic person is expressed by his representative.
Right.
And therefore the court used the intention of the company's representative to show the company had the intention with non-compliance.
Right. Yeah, so that looks a bit like which doctrine? That looks like the identification doctrine. What is the identification doctrine? Identification doctrine. Why is it called identification doctrine? Yeah, and why their actions? Yeah, because they are some of the brain of the company, as it is sometimes described. So the identification doctrine considers that the liability is a criminal liability of the juristic person itself. The juristic person, however, cannot act itself, therefore, which are the persons that define what the company wants? Well, these are the directors. They are basically making or developing the will of the company. And for that, the Supreme Court has made a reference actually to the Civil and Commercial Code, which says for juristic persons, the representatives form the will of that juristic person. However, this is also very similar to what the identification doctrine, which we have learned, which actually is a very prominent doctrine in the UK and in other common law countries, which apply this doctrine as well. So this kind of liability is a liability of the juristic person itself, and therefore the doctrine or this way of reasoning tries to find out, well, how can now the actions and the will of the company be found? Well, you need to look at the directors. And I argued last time that the reference to the civil code is not necessary, I would say. However, I think the reason why the Supreme Court made this reference was because they were aware that they were about to make quite an innovative decision, which does not really have a good basis, I would say, in the criminal code. So therefore they tried, I think, to find some other legal basis for establishing this way of reasoning, which they could find in the Civil and Commercial Code, which, however, is not a criminal law. So in the end we may say it looks like the identification doctrine, but it is not named like that, and even the reasoning is using civil and commercial code provisions to support that kind of finding. So there is still a bit of doctrinal uncertainty here, I would say, even though this decision is dating back many decades now. Alright, so that was the way how the Supreme Court reasoned in that case. Now, in the second case that we just briefly already looked at, the Bangkok liquid gas explosion case, that was a case about negligent acting. In this case, negligent killing. In that case, the court could therefore not refer to the Civil and Commercial Code because it was not a case about intentional wrongdoing. So obviously the section that was used was about the formation of the will of the company, which can only apply to intentional wrongdoing. So in the case of negligence, what did the Supreme Court do there? So what was then the way of reasoning in the second case that we looked at? If the Civil and Commercial Code was not used there. So the Supreme Court stayed within the criminal code, did not make any references to other legislation, and basically considered that the omission, or you can say the negligent disregard of certain duties by the director of that company, so that was, I think, Cyan Gas, that the director's negligent disregard of the duties that he as a director has to control what other members of the company, and particularly employees, what they do, that this negligence could be attributed to the company. How? Well, the Supreme Court here, as I said, did not make any particular reference to other laws and did not really establish a doctrinal basis for this finding. But we may even say, well, this is then just the identification doctrine, without, however, mentioning it. But as there was no reference to the Civil and Commercial Code, we may say maybe that is then indeed the investigation doctrine in its real form, within the criminal law. This provision, or you can say this decision, produced even more criticism among scholars. Because here, obviously, the court was now not even making any reference to any other provision anymore, and just consider that that is somehow normal, that what the directors do and what their state of mind is, that that can be attributed to the company. But obviously the criticism that was then raised was the criminal law has a very strict understanding of how to apply it. So analogies are not permitted, obviously, and the law must clearly state what shall be criminalized. So therefore, the nullum crimen sine lege principle is very strict in criminal law. What you cannot find in the wording should not be the basis for punishment. And here, the criticism was, well, in the first decision about the intentional wrongdoing, at least there was a reference to some basis in the law, even though it was only private law. And in the second case, there was then no reference at all anymore. So it was basically implied that this is what the criminal code intends. That whoever is just also a juristic person, so we don't need to mention it anymore. It's just clear now. Whereas I think in legal scholarship it was not yet clear, and it was still a debated issue. The Supreme Court seems to have already adopted this position that that is now clear. That is now established law. Right, so therefore we may indeed say the way how the Supreme Court has approached these kind of cases is to consider that whoever can also cover juristic persons, and then the directors are the ones who can or who represent the person, and their actions and omissions and their intention is then the company's intention. And that very much looks like the identification doctrine, but it's not explicitly said by the Supreme Court. Maybe also because the identification doctrine is a common law doctrine. Now, let's therefore look at a summary of the Supreme Court's conditions. If you look at the different decisions and try to put them together into a certain, you can say, catalog of requirements for corporate criminal liability, then we may say, well, first of all, as we have just said, the perpetrator, so the actual perpetrator, needs to be a representative. We will in a moment see that this term has now been enlarged in the subsequent Supreme Court decisions, not only to cover the directors anymore, but also other persons. So it is extending, and therefore the doctrine is now, we may say, developed further and is maybe not that pure anymore, because now it seems it is more becoming a vicarious liability approach. We will see it in a moment who is covered as a representative. But let's just stay with the other elements here. So the perpetrator acts or omits within the powers conferred on him in the legal person's interest. The legal person receives a benefit as a consequence, and the intention and negligence of the representative is then attributed to that company, or maybe it is its intention. You may not even say it is attributed to it, but it is the company's intention. What the representatives want is the will of the company. Yeah. Exactly. Why can we say that? Because if we move now from this list of elements to again look at representatives. Yeah, so the term representative of the juristic person, is for sure board of directors and managing director. That is classic identification doctrine. But you can see here several Supreme Court decisions. One of them is actually the liquid gas explosion. No, sorry, the trademark case, where managers, managerial board, managing partners have also been considered to be the representatives. Not necessarily only the directors or board of directors. So that what we may now say is the way how the Supreme Court looks at this is, it does not limit its perspective to the identification doctrine in the narrow sense, but also other persons who have managerial power may be the ones who can trigger the company's liability and may, in that case, then represent the company in that particular field of economic activity. But for them, you may doubt a bit whether they are really the brain of the overall company, so whether it's really then them who represent the company as a whole, or whether they represent maybe a certain commercial activity of the company, but maybe not the company as a whole, which is then, as you say, it becomes some kind of a mix of identification doctrine and vicarious liability. It is still not every employee on every level who can trigger the company's liability, but it is already extended now. So it is a bit, you can say, blurry. It's a bit, maybe not the pure identification doctrine anymore. But again, it was also never referred to by the Supreme Court as the identification doctrine. It just started with the decisions that looked at the representatives in terms of the directors, but then extensions occurred. Yeah. So therefore, we may now say the current state of the reasoning to establish the criminal liability of juristic persons is still in a flow, is still developing, and we may say it is extending the sources of liability, or you may say the persons who can trigger the criminal liability of the juristic person is growing. The number of them, or the scope of them is growing. And you will see in the case study that we look at, or the case that you will solve later, I introduced, or I used a law, which is the Organic Act on the Prevention and Suppression of Corruption from 2018, a new law, which has now even moved further than that, explicitly however, so there is no doubt about where does it come from, or what is the doctrine. But you will see that in this law, who can trigger the liability of the juristic person is any person who is acting on behalf of the juristic person. So that is then really, you could say, the furthest extent that it can take, and that is obviously not a identification doctrine anymore. That very much looks like a vicarious liability approach. So we may say what the Supreme Court has developed for these general cases, where it's whoever, where it seems that the representatives and some others are the focus who can trigger that liability. The law has now moved on already. So the latest laws which have been created in Thailand that establish juristic person's liability, for example in the field of bribery, these laws have now basically established a way, or a concept where everyone who acts on behalf of the company can trigger the criminal liability of the company. Yeah, so we may even say what we have learned here now is already not outdated, but it is, you can say, surpassed by some specific laws which extend the number of people who can trigger the liability even further. But that is the case that you will solve later, so therefore we may not yet go into that. So what we have now covered so far, therefore, is the corporate criminal liability under Thai law, particularly taking into account Supreme Court's decisions. Nonetheless, as I said already, there is another form, an even broader form in more recent acts, such as the Act on the suppression of corruption, or prevention and suppression of corruption. Now, moving from the corporate criminal liability to directors' liability, we will see now another quite fascinating development in Thai criminal law, involving even the Thai Constitutional Court. So, obviously we just said the directors are the ones who are representing the company. That is what the Supreme Court has established. But the question is, what about their own personal liability? So criminal liability of the juristic person exists side by side with the criminal liability of individual persons, particularly the directors. So one is obviously not excluding the other's liability. Both can be criminally liable, and often are. You will also see that in your case studies, where there is, or your group work, where you have cases where companies and individuals have been prosecuted. So individual criminal liability follows obviously the normal rules that always apply, but I mean these rules also apply to juristic persons. However, reasons for justification or excuses may not be that relevant for juristic persons because they may be rarely under any form of duress or other situations. For individuals that may sometimes play a role, although in the business world it's also rare that someone has sort of self-defense as a point of justification or any ground of necessity. Also rather rare, but we may think of that maybe more often when we think about individuals' criminal liability. So obviously physical, mental elements of the offense, then justification and excuses. That's the general way how we look at criminal liability. Now, which are the laws that are applicable for particularly now directors' liability? Well, obviously all general criminal laws apply without a problem. Now we also said, well, they now also apply to juristic persons, so I mean, that's the extension already, but obviously the criminal code, by its nature and also I think by the drafter's intention, particularly and in the first place, applies to individuals. So obviously the directors as individuals are covered there. But then there are also some specific offenses of legal persons' representatives, and these are the ones that we will have a look at now. So obviously the general criminal code, that is what applies anyway, and you may consider that, for example, fraud, embezzlement, but even also manslaughter and killing may play a role sometimes. So the whole scale of criminal liability is applicable. Well, obviously some crimes are maybe less prevalent in the business world than others, but in general everything applies. So we will have a look at the more specific offenses here. And there are two kinds of provisions that we may distinguish. One kind of criminal liability is what we can describe as genuine individual criminal liability, where also, interestingly, natural and legal persons may be joint principals according to one Supreme Court decision. So we will have a look at some of these provisions in a moment, and then derived individual criminal liability connected to a legal person's criminal liability, where the provision would say if a legal person has been found guilty, then also the representatives are to be found criminally liable as well. But this second category is not without problems, because I already put now here the question mark. Does that mean a presumed fault of the representatives? So is there some kind of presumption of guilt involved here? Which could be a bit of a problem, because the criminal law works according to the presumption of innocence, not the presumption of guilt. So these derived provisions are a bit of a challenge, and we will see that these provisions actually even made it up to the Constitutional Court to look at them a bit more in detail. Okay, but now the genuine individual criminal liability, these are provisions that very clearly refer to the criminal liability of certain persons within a company. So again, just random examples, you will find dozens or even hundreds of these kinds of provisions in different laws. So I just picked out some examples just to illustrate how these provisions would look like. For example, in the Securities and Exchange Act, any director, manager or person responsible for the operation of any juristic person under this act who dishonestly deceives the public and so on, and then there will be a punishment. Or up to 1 million baht on that. Yeah? But here you see rather clearly who is covered here. Specific, genuine, you can say, criminal liability of these persons. Not derived, so it's not necessary that first a juristic person is found liable. That is not mentioned in these provisions. It is directly pointing to certain actions, yeah? Deceiving the public, for example, in these kind of cases here, where then this action triggers the liability of these persons. Well, another example, the Financial Institution Business Act, again, yeah, any director, manager, or person with power of management of a financial institution who commits or refrains from any commission in order to obtain any unlawful gain and so on. Now the content of this provision is not that interesting for us, but we see again that certain persons are covered here. Interestingly, you see, even though this is criminal liability of individual persons, the punishment is quite high. Yeah, so we've seen in the previous one 5 to 10 years and a fine of 500,000 to 1 million baht. Or here again, yeah, similar 5 to 10 years, 500,000 to 1 million baht. So we see that some provisions, which have also then been updated in the meantime, have for individuals found rather high ranges of punishment. Still obviously fixed at 1 million at the maximum. But if you compare these provisions to the ones that we've just mentioned before, where negligent manslaughter nowadays up to 200,000 baht, and that applied to companies just appears very minor, if even now individuals can be fined up to 1 million baht. So the imbalance becomes even more obvious if now new provisions extend even the punishment for individuals to that level. Then this low punishment for companies becomes even more disconnected, you would say. Okay, now that is obviously an easy case. Let's look at the derived criminal liability. So again, what does it mean derived? It basically says, or this category basically says that there needs to be some criminal liability of the juristic person first, and from that, or somehow attached to that, there shall also be individual criminal liability of the directors. An example is section 114 of the Trademark Act. Again, only one representative provision out of many other acts that have similar provisions. So let's have a look at this provision, because we will later also see that this provision, or this kind of provision, has now become the way how these cases are dealt with. In the case where an offender is a juristic person, if the offense committed came from the Order Act, failure to give an order or failure to act as required by his duties as a managing director or any other person responsible for the operation of such a juristic person, so a rather wide range of persons who are covered here, such person shall also be liable to the penalty prescribed for such offense. So obviously you only need these kind of provisions if there is no specific individual liability of directors before in any other provision. Because otherwise you would just say, well, the provision that says, for example, whoever will cover juristic and natural persons anyway, so you would not need this kind of on-top provision. So obviously you only need such a provision if the other crimes which are established are only applicable to the juristic person. And then this kind of section then also says, on top of that, once a juristic person has been found liable, also the directors and the others which are mentioned here shall also be criminally liable if they, and that is important, if they have ordered, acted, or failed to give an order or failed to act. Yeah, so again, this provision would not be necessary if there is already a genuine own criminal liability of these persons. So in these cases, obviously, the Trademark Act in this example appears to have certain sections which are applicable only to juristic persons, and then backs this up with this provision and extends this then to the individuals as well. Now, keep this the wording of this provision in mind, so I again point you to the important aspect of this provision, because it says, if the offense committed came from the order, act, failure to give an order, or failure to act as required by his duties, then such person shall be liable. So, imagine you are a prosecutor, and you are in court. What do you need to prove here in order to find, let's say, a managing director liable? What do you need to prove under this provision? What are the elements of the crime that need to be proven here? What needs to be proved here? Yeah. Okay, but let's maybe start now from the top. So what are all the elements that need to be proved in order to, in the end, find this managing director criminally liable? Everything. What are all the elements here? What is the first thing you need? An offense by a juristic person. That's the first thing that needs to be proved. Okay. Alright. Then, what else? You need someone in that particular position that is required. So you need to prove that the person that you have indicted is a managing director or any other person responsible for the operation of such a juristic person. Also, that needs to be proved. You need to prove that this is such a person. And then you will need to prove that this person has ordered, acted, failed to give an order, or failed to act. That is also what the prosecutor must prove. And then, as you say, some kind of mental element is also required. In this case, what would you say? Is negligence enough here, or does it need to be intentional? So what about a negligent failure to act? Would that be covered here? What did you learn in your criminal law class about the criminal liability for negligence?
It's basically we acted below the required.
Okay, yeah. So what it then means is you have not met the required, you can say, duties of care, or the standard of care. But when is negligence punishable? It needs to be explicitly mentioned. So the criminal code says that, so I think I even put that here on your case studies. Let me just see. So if you look into section 59, you will get these sheets in a moment. Section 59 of the Thai Criminal Code says a person shall be criminally liable only when such person commits an act intentionally, except in case where the law provides that such person must be liable when such person commits an act by negligence. But that then needs to be explicitly stated, that negligence shall also be a ground for criminal liability. So you may say, if the law doesn't say anything, only intention as a ground for criminal liability. No? So in this case, only intention. No? I don't see any reference to negligence here. So a negligent failure to act under this provision would not be covered. Sorry. Sorry? Yeah, omission. Yeah, very good. Yeah, so I mean, failure to act, but it needs to be an intentional failure to act, an intentional omission. Yeah, so a negligent omission would not be enough. So you basically need to know that by your omission a certain consequence will occur. Yeah. That is general criminal law, yeah, always applies. So wherever we are in which act, as soon as you find a criminal provision, you need to see that the whole general part of criminal law is somewhere in the background. It always applies. So the general rules, even though the criminal code is not explicitly referred to, the criminal code established a general set of rules that apply always when we apply criminal law. So they don't need to be repeated in every act where criminal provisions are to be found. Okay, so that is everything that needs to be proved. So intention in the end as well. But importantly also, certain orders, acts, or failures to give an order need to be proved. Now, let's have a comparative look at section 54 of the Direct Sales and Direct Marketing Act. In the version until 2017, already indicating to you this has been changed, and there was also a reason why this was changed. So here you can see, so the previous provision was, derived, but not really fully derived, because the prosecutor still needed to prove a certain act or failure to act. So the mere liability of the juristic person itself did not, or was not sufficient. The prosecutor still needed to prove a particular action by the directors and these other persons also. But let's look at section 54 of this act, and there have been about more than 70 acts in Thailand that use the same kind of provision. It's all changed now, but this is how it was until 2017. And where do you see the problem here? So what is the wording? I'll just stay here so you can see it. In the case where the offender who is liable to punishment under this act is a juristic person, so that's similar to what we've seen in the Trademark Act previously, the managing director or manager or the person responsible for the operation of such juristic person shall be liable to the punishment imposed by law for such offense, unless he is able to prove that he was not involved in the commission of the offense of such juristic person. What is the difference between this provision and the previous provision? So it starts in the same way. Liability of a juristic person, that needs to be given first. But then, what's the main difference here? Yeah. So what is it under this provision that the prosecutor needs to prove here? There's still something that the prosecutor needs to prove. What is it? And that the defendant is the managing director or manager or the person responsible. That is also something, so the position would also still need to be proved. But for the rest, the burden of proof shifts to the defendant. The defendant has to defend himself or herself and has to prove that it was not him who acted or her who acted wrongfully. So obviously a very comfortable position for the prosecutor. The prosecutor only needs to say, well, there was here this juristic person's criminal liability, which we have established. You are the managing director. So you are presumed criminally liable. And if you don't accept this, then you can defend yourself and try to prove that you did not do this. Now, what may be a problem with that? Yeah. Now that's the general rule in criminal law or criminal procedural law. The burden of proof in criminal law is on the side of the state, that means the prosecutor. Here, however, the burden of proof is shifted under these conditions to the defendant. That seems to be quite a big departure from what we are used to in criminal law. Now the question may be, is it possible that some of the burden of proof is shifted to a defendant, or is the presumption of innocence absolute? So could we accept maybe to a certain extent, that some elements of an offense may be not need to be proven by the prosecutor, but maybe the majority of it, but maybe some not? Or is the presumption of innocence completely absolute that every element of the offense must always be completely proven by the prosecutor? What would you say? Is the presumption of innocence absolute? If I'm already asking like that, maybe not. Yeah? So the question here is this a presumption of guilt that violates the presumption of innocence principle or not? Now, the fact that this was in the end changed indicates for you where this was going too far. This was indeed unconstitutional in the end. But I would now like to, or maybe we just look at this, how this was then decided. Yeah, so the Thai Constitutional Court received the question by, I think, the Buriram Provincial Court, which had a case under the Direct Sales and Marketing Act, a criminal case, and the defendant raised the question, is that really constitutional here, this law, on the basis of which you try to find me guilty? Because it seems to have a presumption of guilt in it. But if I look into the Constitution, and also the 2007 Constitution, contained a presumption of innocence, and how can that now be true? And then the case, as you know, one possibility, or you could say one channel to the Constitutional Court is by way of a direct reference from a court to the Constitutional Court to ask for clarification about the law, and to also clarify whether the law is constitutional or not. Then the Constitutional Court decides, gives this back to the court, which is about to apply the law, so in this case then the Buriram Provincial Court, and then the court can decide based on the new interpretation or the clarification of the Constitutional Court. So in this case, the Constitutional Court said Section 54, the one that we've just seen, is unconstitutional because it violates the presumption of innocence back then in Section 39, paragraph 2 of the 2007 Constitution. In the current Constitution of 2017, it is in Section 29. There you find the presumption of innocence nowadays. But the law has, the constitutional law has not changed. The presumption of innocence remains an element of Thai constitutional law. Yeah, so here you have not only an example of corporate criminal and directors' liability that has somehow been going too far, but you have also a very interesting example of a decision of the Constitutional Court invalidating a law based on individual rights protection. So, that's just happening not that often, yeah? So it is worthwhile to point it out that the Constitutional Court has here invalidated a law to protect individual rights. Well, actually there have been, under the 2017 Constitution now, at least 3 provisions that I'm aware of that have been invalidated for other reasons, not now for presumption of innocence, but for other reasons where also the Constitutional Court considered it. So it happens every now and then. However, the very interesting issue here is it was a 5-4 decision. That means 4 judges were convinced that this provision was okay. So it seems not to be such a clear-cut case, and that was the reason why I asked you, is the presumption of innocence absolute? Or can there be some exceptions from it? So the minority opinion obviously considered this was not a problem. On the one hand, here they said, well, it is basically a chance to prove that you didn't have any part in the decision making. I wonder whether that is sound reasoning. Yeah, well, considered to the normal situation where you don't need to prove anything, I wouldn't really see that as a chance, but as a burden, an additional burden that usually would not exist. So that reasoning may not be fully convincing. But the other reasoning is quite interesting. So what we have learned so far, we learned, according to the doctrine that has been adopted by the Supreme Court, juristic person's liability is triggered by the director's wrongful actions. So basically what these judges then said was, well, in order to find the juristic person liable in the first place, which is one of the requirements, if you remember, so one of the requirements under this provision has been that first of all the offender needs to be a juristic person. But what we just learned was, well, juristic persons are only liable under the classic doctrine which the Supreme Court adopted if the representatives of the juristic person have committed a wrongful action. So basically what the minority judges, here the 4 judges, argued was, well, the legal person's criminal liability already requires proof that the directors were also acting wrongfully. So basically then making them again under this provision criminally liable is just nothing unusual, because we already, in order to prove the juristic person's liability, we already looked at their liability and at their wrongful action, and we already established that. So without their liability, the juristic person would not be liable in the first place, and therefore it doesn't really add any burden. Now, does that reasoning make sense? Yeah, but so what these judges basically say is this presumption doesn't really cause a problem, because in order to find the juristic person liable, we already looked at the directors. Yeah, they have already been proven that they did something wrong, because without them doing something wrong, the juristic person would not be found liable. So this is not an additional burden, they said. But then you may ask yourself, but why do they have to then be found liable under this provision? So if we then found them liable under another provision, then what is the reason to have then on top of that this provision? It seems to be some kind of double jeopardy, or double criminalization. Now, I think that this reasoning does not fully make sense. Because you may ask yourself, well, why does such a section like section 54 or the trademark law exist? We mentioned that already before. Well, you would not need such a section if there is already another basis or another law on the basis of which the directors can be found individually liable. Then you don't need this second trigger, well, if the juristic person is liable, then also the director is liable. You only need these kind of provisions if there is no other way to establish the individual liability of the directors. Then you may have such a provision. That means in this case, section 54 of the Direct Sales and Direct Marketing Act, we need to consider that this is the only provision under which then the directors could be found criminally liable. That means we have not yet found them criminally liable on their own. We only looked at them to consider the juristic person's liability, but that was under the question of juristic person's liability. So therefore, I think we still need to separate these two issues. For their liability, for the individual director's liability, the presumption of innocence, I think, still requires that we need to individually for them establish their guilt as well, even though we may have already looked at their wrongdoing earlier to find the juristic person's liability, but that was the juristic person's liability, that was not yet their individual liability. These are two separate issues. Even though you may in the end look at the same facts, and you may come to the same conclusion, but legally the individual directors deserve the presumption of innocence. However, One thing that the minority opinion did not really address was, well, maybe even taking into account that this is indeed a presumption of guilt, can we maybe just justify that as an exception from the presumption of innocence? As I just said, the presumption of innocence is not absolute. There may be exceptions, particularly to facilitate the prosecutors and the police work. Because in some cases it may just be very difficult to prove something which, for example, happens within a certain organization. So then certain prima facie evidence, which you may usually know from private law and civil law cases, but certain prima facie evidence may then, even in criminal law, also reverse the burden of proof, even though it's criminal law. That is not completely excluded. And I would like at this point maybe, because here, we are then looking at the other provisions, I would just like to make you aware. So there has just been one of my master students who looked at this in more detail in a case about insider trading, where also these kind of provisions have been used. And she also looked at the way how maybe presumptions may be, you could say, okay. So this is now a bit, you can say, not off topic, but it is really now looking at this specific problem of presumptions in criminal law. Well, this is now not fully convincing yet. Just close this one and drag it over a little. So my master student has then analyzed insider trading provisions that currently use the same or a similar presumption, not the same, a similar presumption. And her question was then, these insider provisions, are they in violation of the constitutional law? Because based on this decision that we just looked at by the Constitutional Court, we can say under certain circumstances, presumptions may be unconstitutional. So the question was then, were the provisions in the insider trading provisions, were they maybe also unconstitutional? And according to one publication then, which was a comment on that decision of the Constitutional Court, that scholar has developed, or has basically said, the Constitutional Court of Thailand uses a so-called pattern approach to consider whether or not a presumption of guilt or other forms of presumptions, whether they are constitutional. So the basic fact, that is basically the prima facie evidence, so something that the prosecutor still needs to prove. And then the presumed fact, that is then where the burden of proof shifts. And we can basically distinguish, or the Constitutional Court basically distinguishes four patterns of possible kinds of presumptions. So the first two look at the status of the defendant. So, for example, a director, or a managing partner, or a person who is responsible for the operation of certain business units. So, depending on what the law says, we've seen in the case of the Direct Sales and Direct Marketing Act that referred to what were the groups or the status that were covered here. Let's just have a look at that again. Managing director or manager, or the person responsible for the operation of such juristic person. That is what is then referred to as the status of a person here. So if that status is what is the basis of the presumption, then what could be the presumed fact? The presumed fact could be the guilt of the defendant. That was what Section 54 of the Direct Marketing Act basically did. If you are the managing director and so on, so if you have that status, then it is presumed that you are guilty. Another possibility would be if you are the managing director or the person responsible for the management, whatever it says then in the provision, then you may not be guilty, but a certain element of the crime may then be presumed. For example, intention could then be presumed. Or a certain knowledge could be presumed. pattern that then the Constitutional Court distinguishes: action of the defendant, which would be the basic fact, so not the status, but an action of the defendant which would then trigger the presumption of guilt, or an action of the defendant which would just trigger the presumption of a certain element of crime. Now, in order now to consider what is the Constitutional Court's solution to these patterns, we may then just look at here this one here. So basically we can say the first pattern is unconstitutional, and that is the pattern that the Constitutional Court found in section 54. The status triggered the presumption of guilt. All others are fine. Yeah? So the presumption of innocence is by far not absolute, as you see here, according to the approach that the Constitutional Court of Thailand uses, this so-called pattern approach. And that was also the reason why, for example, in the insider trading, no, that is not just to add this up here, in the insider trading case, according to the pattern approach, the Constitutional Court of Thailand would most likely not find any problem with the insider trading law. So you will learn the insider trading provisions later also in this course, but this particular issue of presumptions, we may also now look at this. There's the table. So let's see here. So just now, this is now very specific here for section 243 of the Securities and of the Security and Exchange Act. So here you can see that the pattern approach for this kind of provision, which was not a presumption of guilt, but only a presumption of a certain knowledge, that pattern approach would actually come to the conclusion that all of that is constitutional, so these presumptions are all fine. Whereas there are other approaches which I think are more convincing. So for example, US Supreme Court uses a so-called rational connection approach that asks, is there a rational connection between the basic fact, so that is the prima facie fact, and the presumed fact? Can you rationally infer the presumed fact from the prima facie fact or not? Is there a rational connection between the two? And another, maybe I would even the most convincing approach, the principle of proportionality, which would consider, is such a limitation of the presumption of innocence proportionate for the purpose of increasing the enforcement or improving the enforcement of criminal law. And you can see here very interestingly, so at least my master's student then came to the conclusion that under these two, at least one provision in the current insider trading law in Thailand is unconstitutional. Whereas the approach by the Thai Constitutional Court, even though it found that direct sales and direct marketing provision unconstitutional, in this case it would actually most likely come to the conclusion that everything is constitutional. Now, this just as a side note on presumption of innocence. Yeah? This is an area where we need to be aware that this is by far not an absolute principle. Nonetheless, in this particular case, let's now again look at the provision. Why can we say that this is a pattern that the Constitutional Court considered as unconstitutional? Because, as we have said, everything the prosecutor needs to prove is only there was an offense by a juristic person and you are the managing director. So the status that you have triggers a presumption of guilt, not only a presumption of a certain element of crime, not only maybe that you were acting intentionally or whatever, but it establishes a full presumption of criminal liability. And this pattern is one where the only pattern where the Constitutional Court of Thailand would also say that goes too far, because it presumes the full criminal liability and then shifts the burden of proof completely. So therefore, in this case, the pattern was that which the Constitutional Court considers as unconstitutional. Yeah, so therefore here, the Constitutional Court decision obviously was not the only one. There was a string of decisions where similar provisions and other laws have also been struck down. For example, yeah, in the Copyright Act, the Telecommunication Business Act, Entertainment Value Act, Fertilizers Act. So here, very interestingly, the Constitutional Court really basically said, well, we said that before, so whenever then a new provision was brought to the court, because another court then brought this request to the Constitutional Court, what about this provision, what about that provision, they all have the same wording, like the one that you already declared unconstitutional. Well, and in order to be consistent, the Constitutional Court found every of these provisions unconstitutional. So that obviously after a certain while the government thought, well, we should do something because many provisions in Thai law are unconstitutional and it's just a matter of time until they get to the Constitutional Court. So therefore, yeah, the military government considered in 2017 we need to reform this. And so, overall, 76 laws were changed with one law. And all of these provisions have been replaced by the kind of provision that we have seen earlier in the Trademark Act, where we said the prosecutor needs to prove a certain action. So let's now look at section 54 in the current version, so since the change in 2017. You can see now the burden of proof is shifted back to the prosecutor. So now this section says where the offender is a juristic person if the offense derives from an order or action of a director or the manager or any person responsible for its operations, or where such person has the duty to issue an order or to take action but failed to do so, thereby causing the juristic person to have committed the offense, such person shall be liable. So here you see again, it is formulated in a way that the burden of proof for all of these elements is with the prosecutor. Of the Trademark Act, exactly. So you may say section 114 of the Trademark Act is some kind of a model for this new kind of provision which is now replaced in 76 acts. I would say a very positive example of constitutional court jurisprudence. Yeah, I mean, we need to mention that. Yeah, there are examples of why a constitution can be a good institution. Other examples, but this is an example which in the end led to the change of 76 acts. That is quite substantial. Okay, so you see here, the director's liability in Thailand has really a very interesting aspect because for a very long time it has used these kind of presumptions which were going a bit too far. But this has now been changed. Okay, yeah, so are there any questions so far regarding corporate criminal liability and director's liability? Well, if that is not the case, then we are now taking a break. But before the break, I already put here the cases here, so you can just, on your way out or wherever, you can just pick up a case. And you can obviously take your break normally, you don't need to read the case at the break. But once you're back in the class room, then start reading the case, and then I will give some introductory remarks on that, and then we will start, or you will start to solve it.
เ
เอาพอดีเอาเย็นมาที่ไหนเอาเย็นแค่ไหนของอะไรปั้น